I'm Gary Tabakman. I'm going to talk to you today about getting the best possible plea agreement in your federal case, and I want to talk to you today about the 8 strategic things that I've come up with that can help you achieve the result that you want. Number 1, I think it's highly important that you start evaluating a case super early. What does that involve and what does that entail? So obviously, getting to a point to where you can effectively and openly and strategically communicate with a prosecutor about a plea agreement, you have to know the facts of the case. You would be astonished at the amount of lawyers that have never reviewed any discovery or have reviewed just a sliver of discovery in a federal case, as their entire goal from the very get-go is just to streamline a plea agreement in order to get the case over with. That is not an effective strategy. It rarely works, and it rarely achieves the result that you want, and it will rarely achieve the result that is truly just and right for purposes of a federal sentence. So what do we do in order to evaluate that case? One is we review the discovery, calculate the guideline exposure, identify certain weaknesses, and we start to determine leverage points. Factors that go into that can vary drastically depending on the case. On a case-by-case basis, you could look at, obviously, the severity of the type of crime that it is, your specific involvement in that crime, the amounts of individuals, who the individuals are that are involved and charged, what their roles were, who did what, when, and how, and understand where the government's case truly lies as far as who's the more responsible, culpable party, and what is the government truly trying to accomplish with this particular prosecution. Oftentimes, prosecutions are based on the currently political charged environment that we find ourselves in. It is not simply accurate to say that this case was charged just simply due to the fact that, well, people were committing crimes. Oftentimes, certain cases get passed on just simply due to the fact that we have either a new incoming U.S. attorney, an outgoing U.S. attorney, a new administration that takes over. So we need to be able to evaluate the case from all of these perspectives, review all of this discovery meticulously, see where the government's case is specifically as to how it relates to you, and then we could start a process of where we could open a door of communication with the prosecutors about what we believe the right approach to a plea agreement may be. This approach usually comes first and foremost from the government lawyers themselves. They will reach out and ask whether or not we're interested in communicating about a plea agreement. The answer oftentimes could be yes, send me an offer. And then we start to look at the offer and how to break that offer down and start to chip away at certain aspects of that offer that can help reduce a recommended sentencing guideline range. The second thing that we do is we have to leverage the timing. So if we engage in early negotiations, we may consider certain pre-indictment plea agreements and understanding prosecutorial priorities as far as the goals that they're trying to accomplish. This may not always be an option in certain types of cases. Some cases start at an investigation phase where you may have received a target letter, and your target letter tells you that you're a target of a prosecution, that you've been subpoenaed to appear before a grand jury, you've been subpoenaed to produce certain documents before a grand jury. This will indicate to you that you have an opportunity, if you know that there's something that you did that could potentially expose you to prosecution, that opportunity can potentially produce an outcome with a very early plea agreement of some sort in order to avoid an indictment and get you the best possible outcome in a case very, very early on. I've handled dozens of cases where someone has received a target letter, and we have either avoided a prosecution altogether, or we have established a line of prosecution that allows for a client to plead guilty to just an information, not an indictment, and allows for us to get the lowest possible guideline range, even a probation, in a federal case, where otherwise, if the client never contacted a lawyer that understands what to do, they end up in a situation where they're facing indictment, they wait too long, and they're actually facing prison time. We can avoid that if we are effective early on. Third, the use of the sentencing guideline range to your advantage. So seeking reductions through acceptance of responsibility, roles, fighting certain enhancements, negotiating favorable stipulations within the guideline range that could help. All of these things can enter the plea agreement talk. So what I mean by that is a plea agreement may oftentimes have very boilerplate language without offering any sort of substance for the court to consider from the very get-go. There are certain things that we want to do within a plea agreement that could lock the government in and lock the judge in to say that this is the negotiated plea agreement that we've come up with because we believe that this is the fair outcome in a particular case. Oftentimes, this is hard to do, but we still attempt to do it because we believe that in an effort to truly achieve a just outcome, it's oftentimes far better to have the language that you want within that plea agreement to give you the desired result, as opposed to fighting through the system of getting that result at the tail end when you're standing before a judge and you've provided just an argument through pre-sentence investigation objections or through a sentencing memorandum. The fourth thing that we need to consider is exploring substantial assistance. So if we talk about substantial assistance such as 5K 1.1 reduction from the government on a motion where you have cooperated, or Rule 35 cooperation, which I will do a separate video on, if you disclose that information strategically and oftentimes earlier on, that could help buy you certain aspects of benefit into a plea agreement that could help you negotiate a better outcome from the very get-go without, again, fighting it at the tail end in front of a federal judge through objections and through the sentencing memorandum that your lawyer may have filed. The fifth thing to consider is a charge versus sentencing bargain. So what is that? Let me explain it to you. Negotiating lesser charges or specific sentencing range through what's called a Rule 11C1C plea is the goal is to obviously avoid harsher consequences. So it's very rare, especially in the Southern District of Texas, where we get what's called a C plea. A C plea locks the government into a certain amount of years. Many of my clients ask, I want a set number and I will plead to that number, because a lot of clients are used to the state system, where in the state system, when we go through plea negotiations, you might start at let's say, just an example, 15 years, and you ultimately, do the whole dance, and you come down to 8 years, and the client's like, I'll take 8. Federal court doesn't work this way. It rarely does, and when it does, it's in very, 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 very specific, rare circumstances where the government lawyers have to go up the chain in order to be able to accomplish that result. Prosecutors, United States attorneys, they don't like doing that. They do not like going up the chain in order to get certain results, because the answer is almost always no, and there's a lot of pressure that's put on them in order to be able to accomplish that type of result. However, taking a tactic of where we start talking about what lesser offenses may fit into a particular plea agreement, sometimes even misdemeanors that could fit into a particular felony that's been charged, and I'm talking about certain types of fraud cases, for example, can drastically help with plea negotiations and can drastically help with the ultimate outcome in a case. One specific thing that I could tell you that really helps with respect to this particular factor is, in a fraud case, considering intended loss amount versus actual loss amount. What a lot of people don't understand in fraud cases is that if you have committed fraud and that fraud had resulted in a loss, as an example, of $1 million. $1 million will be the guideline range that will ultimately be the guiding factor as to where you may fall on a sentencing guideline table, which is determined in this book, in the sentencing guideline manual, and typically on this page where you will find your particular sentencing guideline range. In a fraud case, oftentimes the individuals that have got themselves caught up in a circumstance where they're being accused of committing such a crime, they had a far higher intended amount of money that they were trying to defraud. So hypothetically speaking, if you were attempting to defraud the government of $5 million, but you were only able to get $1 million, your guideline range will actually be based on the $5 million range versus the $1 million range. So one strategic benefit of a plea agreement negotiation could be that you could tell the government, we'll agree to sign a plea agreement, but we'll agree to sign it based on the $1 million loss amount, not the $5 million intended loss amount. This obviously can significantly reduce your guideline range and can give you the opportunity to argue to the court that based on our plea agreement, the appropriate guideline range should be X versus Z. The sixth thing, building early mitigation. So if we are able to provide early mitigating evidence about you, such as character letters, treatment records, potential restitution efforts in order to humanize you as a person. It can help in the negotiating factors within a plea agreement because a prosecutor can help develop a much better understanding of who you are. So, as an example, I frequently talk to U.S. attorneys that have to understand the impact of a plea deal and a plea agreement or sentencing of prison time for individuals that have never been to prison before, have never been in trouble before, and have never been arrested. The impact of that is very heavy because prosecutors understand that individuals such as yourself may come from families that are large, with children, kids in college, kids in high school, parents that are still alive. There's so many factors and so many influences that can occur within that environment, and somebody being charged in a federal case can have such a drastic and life-altering course of action within a human existence that prosecutors themselves get very, very affected by it. Our job is to help advocate for you in that space. So a strategic effect of what we can do in order to help negotiate a better plea agreement is early on to start to mitigate and help you accomplish what we are seeking to do in the same context of what we would do with a federal court judge at sentencing. We want to do the same thing with the prosecutor earlier on so they get an opportunity to know who you are. I've been involved in plea negotiations where I have provided almost an entire sentencing packet or sentencing memorandum to a prosecutor way early on in the case for them to get to know who the person is in order to garner leniency through a plea agreement. This can be effective in many different types of cases. It can especially be effective in cases where somebody is young, somebody that has never committed a crime before, or somebody that's charged with a nonviolent offense. So we want to be able to establish that link early on, develop a rapport with the U.S. attorney handling the case early on, and it could help buy you the benefit that you need in order to accomplish a much better result at the end. Number 7 is managing the plea process itself. So we want to avoid what's called open pleas, review plea terms carefully, and consider appellate waivers cautiously. So there are certain aspects of this that are a little bit more convoluted and complex that can be explained in a 10-minute video, but I will tell you this way. So an open plea is a process of where you have absolutely no plea agreement. Basically, you go to court and you just plead to the indictment as is. Obviously, that comes with a certain amount of risk simply due to the fact that you're completely open to the court for purposes of how the sentencing guideline is ultimately determined and what that range of punishment will look like for you. It is an effective strategy, however, in certain types of cases where you know that entering into a plea agreement has absolutely no benefit to you. The one thing that I could tell you is that a plea agreement is only as good as the benefit that you get from it. If there's no benefit to a plea agreement and the government is just trying to tie your hands behind your back and send you to prison without any sort of benefit whatsoever, you need to run. There's absolutely no way for you to enter to that plea. You may as well go to trial, you may as well roll the dice, and you may as well see what the outcome through that particular vehicle would be, as opposed to signing your life away to something that you already know will just end up being a prison sentence. An open plea can sometimes help, though, because you may be able to negotiate certain factors within an open plea that still protects your appellate rights. Most plea agreements come with a waiver of appellate rights, which automatically stops you from the ability to appeal a case unless a judge goes significantly above a recommended sentencing guideline range. So these are things that we need to talk about early on, and for you to be able to understand the impact of the 3 things that typically happen within a federal case, which is 1, we either enter into a plea agreement, an open plea, or trial. And what does it all look like for purposes of sentencing? Last but not least is preparing for sentencing. So within the plea agreement environment, within the plea agreement itself, we need to understand the impact of the plea agreement and how it will ultimately impact your sentence, and the 3553A factors, which I've discussed in the video linked here above. You need to begin, again, the mitigation early, rehabilitation early, and start planning on negotiations that will ultimately help you achieve the result and impact at sentencing. Your plea agreement, especially the factual basis within the plea agreement, needs to comport with how you're going to argue to the judge strategically what the outcome in your case should be. If there are things within the plea agreement that are not beneficial to you, that can hurt you in the long run, and that can potentially create certain pitfalls, we want to try to get those things out of the plea agreement. As an example, I could tell you, in my experience, that the factual basis in a plea agreement can drastically impact how a court views your role and your involvement in a case. Why is that the case? Well, the reason being is because a federal judge who has not sat before your particular case listening to every single fact through a trial, the only thing that they know is what's been provided to them from the government. What's been provided to them is in the PSR, which is the pre-sentence investigation report, the factual basis within a plea agreement, and what we have provided in the form of a sentencing memorandum at the end of your case during the course of sentencing. If the information that's within the plea agreement is harmful to you or harmful in the way that it portrays your role, and it impacts your case in a way to where it either adds points through the guideline range, or it helps, or it actually contributes in portraying you as someone that's much worse than the reality of what the case includes you in, you need to take that language out, and you need to make sure that the lawyer effectively reads the plea agreement and breaks each and every aspect, each and every sentence with you, because that can help determine many, many months, if not years, in a sentencing. If you find this information valuable, or if there's a way that I can help you in plea negotiations, just click on the link below for a free consultation. Thanks.